The battle for the soul of the People's Democratic Party continues as the Turkey-led PDP Board of Trustees met, as well as the Iron Group have met, and they're making decision on the way forward for the party. President Bola Tinubu has requested for the confirmation of appointment of Mr. Taiwo Oyedele as minister, and Magnus Abe and others for confirmation of the Senate. It's the most beautiful day in the year. Thanks so much, everyone, for joining us tonight. This is Politics Today, live on Channels Television. I'm Sean Kimale right here for you, bringing to you all your top stories as far as politics is concerned in the country. So much to bring to your table tonight. We're going to dissect and let you in. You are not able to be in the room, but I'm going to bring to you all of the details of what happened on the two camps of the People's Democratic Party in the post-APGA's judgment. And we'll bring you up to speed. But today also, we'll be reflecting on the 2027 election, the electoral law, the future, whether or not INEC is ready for this election, and some of the gray areas identified in the law and what this means for you as a voter. One of my guests is one of those who sat and decided that there might be a boycott on the election as decided by IPAC, the Inter-Party Advisory Council. But before we get into all of that, let's serve you with some of your political roundup stories.
The Chief Justice of Nigeria, Justice Kudirat Kekereekun, is calling on judicial officers to strengthen their understanding of competition and consumer protection law as cases in these areas become more complex in Nigeria's economy. Justice Kekereekun stated these are the opening for strategic judicial training on competition and consumer protection law, organized by the National Judicial Institute in collaboration with the Federal Competition and Consumer Protection Commission in Abuja. She noted that with the rise of digital market, fintech, and artificial intelligence, the judiciary must remain prepared to address emerging legal issues while protecting consumer rights and market integrity. The Minister of the Federal Capital Territory, Mr. Nyesom Wike, is promising that the Abuja University of Technology, APGA, will commence operations before the end of the administration of President Bola Tinubu. Mr. Wike made this disclosure during his thank you visit to APGA Area Council. The FCT Minister also upgraded the status of all second-class chiefs in the FCT to first. The Chief of the Air Staff, Air Marshal Sunday Aneke, is urging Independent National Electoral Commission (INEC) to strengthen collaboration with the military to address logistics challenges in Nigeria's elections. The Air Chief gave the advice at a meeting with the INEC chairman in Abuja. The Air Chief urges INEC to leverage the military to improve logistics, security, and planning to deliver effective election management. Lastly, to Rivers State, where workers at the Port Harcourt International Airport today staged a peaceful protest against the proposed concessioning of the airport by aviation authorities. The protest was led by three aviation unions, the Association of Nigeria Aviation Professionals, the Air Transport Services Senior Staff Association of Nigeria, and the National Union of Air Transport Employees. The workers who gathered within the airport premises carrying placards with various inscriptions marched around the facility to register their opposition to the planned concession. They called on the authorities to immediately suspend all process related to the concession until comprehensive consultations are held with the unions.
There you have it. You've been served with your political roundup stories. Let's tell you that President Bola Tinubu has since written to the Nigerian Senate for the screening of and confirmation of Mr. Taiwo Oyedele as Minister of State for Finance, who will be replacing Dr. Doris Uzoka Nite, who says been moved to the Ministry of Budget and National Planning. The president is also asking the Red Chambers to confirm former Rivers South East Senator Magnus Abe as chairman of the Nigerian Upstream Petroleum Regulatory Commission. The requests were contained in separate letters read during plenary by the President of the Senate earlier today.
In compliance with the provisions of Section 1472 of the Constitution of the Federal Republic of Nigeria 1999 as amended, I'm pleased to forward to the Senate for confirmation the nomination of Mr. Taiwo Oyedele as Minister of the Federal Republic of Nigeria. While I hope that this request will receive expeditious consideration of the Senate, please accept, distinguished Senate President, the assurances of my highest regards.
Thanks so much, everyone. You've heard it. That's the request of President Bola Tinubu to the Senate today. But earlier today in Abuja, in the two different parts of the city, the two different group of the People's Democratic Party met. On one hand, the Samuel Ayan, who led a group, were meeting, and they're making plans, as well as the Turaki-led PDP group, where we saw the two governors of the party meeting. So the meeting was led by former Senate President Adolphus Wabara, and which had the governor of Oyo State, Governor Seyi Makinde, the governor of Bauchi State, who is the chair of the PDP Governors Forum, Governor Bala Mohammed, also gathering at that event, and Mr. Tanimo Turaki, and also Omar Damagum. Other members of the party which attended the meeting include the former Deputy National Chairman of the party, Chief Olabode George, and former Information Minister, Chief Jerry Gana, former Governor of Niger State, Babangida Aliyu, and several other prominent members and chieftains of the party. In the opening remarks, the BOT Chairman, Adolphus Wabara, says the judgment of the Court of Appeal on Monday is an opportunity for the PDP to begin again. Let me take you to the other part of town where we saw the Abdurrahman Mohammed-led caretaker committee of the PDP, which had their own press briefing describing the Court of Appeal judgment as a validation of his committee as the authentic leadership of the PDP. According to him, with the judgment over, the committee is forging ahead with the convention plans which have been scheduled for later this month.
I want to use this opportunity to appreciate our legal teams, leaders, party members, and supporters for their encouragement and guidance and prayers. I want to make it clear at this time that the National Caretaker Working Committee remains the only national leadership recognized by the law and the party. The National Caretaker Working Committee is the only legitimate body that can present a candidate in the build-up to 2027 general elections. As such, I urge all stakeholders, party leaders, party members, and supporters to rally around the National Caretaker Working Committee as we prepare to approach activities towards the 2027 general election.
All right, then, there you have it. That's the Abdurrahman Mohammed-led caretaker committee of the People's Democratic Party. So let's take you into conversation around the 2027 elections and the views of those who are driving the political activities. It's getting intense by the day. And of course, we're seeing quite a number of activities here and there, especially from the INEC point of view and those in the political party front. There are a lot of demands being made in the schedule and in the electoral law from political parties and voters ahead of the election. So it's getting really interesting, and a fierce debate is emerging over the proposed or the amendments to the Electoral Act of 2026, with some political parties now warning that the changes to the law will have some very significant impact on the exercise. We saw even a more striking growing threat from the Interparty Advisory Council, IPAC, where discussions about a possible boycott of the 2027 elections came up. Tonight, I'm being joined by the national chairman of the All Progressive Grand Alliance, APGA, a party that holds sway in the governance and the activities of the government of Anambra State with Charles Soludo as the governor of the party on that platform. I'm being joined by Mr. Sylvester Eze Okenwa, who is the chairman, national chairman of APGA. Thanks so much indeed for joining us.
Thank you so much for having me.
I appreciate it.
Yeah.
We'll begin the conversation. And, you know, the last time you muted it just briefly about what could be the implication of some of the gray areas that a lot of Nigerians have identified in the electoral law.
Absolutely.
And this electoral law seems to have some governing and governance structure that is totally different from the 2022. Which a lot, in fact, in choosing candidate for the election,
absolutely,
what you now know is totally different in how you front load. You now need to front load the voter, the membership digitally. Different from what you had in the 2022.
Absolutely.
Now, also, even the modality or the mode of registering your members are now totally different from what we had in 2022. So if you are not understanding this as a party administrator, you are in for a big, big trouble. The timelines have changed.
Absolutely.
Some have been reduced to half, from 360 to 120 days, some from 120 days to 60 days. There's a whole lot that has changed.
Yeah.
In fact, voters need to now be careful about how they monitor the election. For you as a party chairman, what do you think is the most significant change that we need to be worried about?
Well, for me as the national chairman of APGA, because I have to put out this point. One, I'll have my opinion as a lawyer who more or less has significant interest in election and election-related cases. And then, more importantly, as the national chairman of the foremost progressive party that we have in the country. And like you rightly mentioned, the amendment, so to say, or the innovation contained in the new Electoral Act are such that, has some, what I may call dire consequences or significance to how political parties manage their internal affairs. Of course, the Electoral Act 2026 is now an act of the National Assembly, having been assented to by the President of the Federal Republic of Nigeria. And in that, INEC has equally tried as much as possible to comply with the dictates of the Electoral Act. If you look at the Electoral Act 2022, and you juxtapose it with the new Electoral Act, I think there are two major key areas that are of significant importance to political parties. The first one is Section 84, which more or less deviated from what we used to obtain or what was obtainable under, of course, the Electoral Act 2010 and the 2022, which stipulated three modes of primaries for political parties: the direct primaries, the indirect primaries, and then the consensus. And now, under Section 84, the National Assembly stipulated only two modes of primaries. It says either political parties, decide to nominate their candidates using direct primaries or consensus. And when we make this point, it seems people in interpreting that section do not even really understand certain other connotation. It's not just with respect to nomination of candidates. That particular section equally governs, and other sections governs the election of party officials, because it's very important. So it talks about primaries, congresses, and convention. And you and I know that officers of political parties are elected at either congresses or convention. And so that particular provision equally governs the election of party officials. So Section 84 has been identified as one of those key provisions. Of course, you mentioned or you made allusion to the session held by IPAC last week, which I'm going to come over to in a short while. Then the second one is the provision of Section 77, which now mandates all political parties to digitize their membership database in such a way that before any primaries, congresses, or convention, such digitized database will be submitted to the electoral body, which is INEC, 21 days before that particular primaries, congresses, or convention. And so these two provisions have been identified as one, like I said, that has significant consequences to political parties in terms of the organizational structure. IPAC is of the opinion, of course, predicated on various Supreme Court decisions, particularly the popular decision of Okafor and Onoa, which seems to be the locus classicus on this issue, that political parties ought to have some measure of leverage or liberty or flexibility in the nomination of its candidates. But there is a very interesting point, my brother Shehu. And that interesting point is, when you mentioned IPAC, of course, IPAC is the umbrella body that regulates all political parties in Nigeria. APGA, APC, the PDP, the Labour Party, the ADC, all of us are members of IPAC. And that is the only body that is recognized by the electoral body, the commission, of course, which is constitutionally empowered to monitor the activities of political parties. And decisions of IPAC are taken by majority of political parties present and voting. That doesn't necessarily mean that your political party may agree with the position of IPAC. Why do I say this? Before now, I'm talking about Section 84. The position of APGA as a political party may not necessarily align with the position of IPAC. Now, our position is simple. Even before this Electoral Act was passed, APGA had already mooted the idea of amending its constitution to recognize only direct primaries as the mode of primaries. And so it now seems as if the Electoral Act has now been tailored to suit or along our expectation or our plans, because we believe, in my opinion, and then rightly, of course, the national leader of the party, Professor Charles Chukwuma Soludo, before he came into office, I remember then I was a national legal advisor, and we had some, very lengthy conversation on how to strengthen the party, because the most important thing here is about strengthening the party. And he says that the arbitrary mode of conduct of primaries using indirect primaries, of course, where you have what congresses, most cases undemocratic, may be aligned or tailored to just meet the needs of one particular or
so for the sake, apologies to cut in. So for the sake of our viewers who might be thinking, what is the difference between direct and indirect?
Now,
direct is where literally all members...
direct primaries connote all duly registered members of the party are allowed to vote
for a candidate in a particular
primaries or in the nomination process.
While
indirect is more like an electoral college. Exactly, a collegiate. Where still, if you even look at it, every indirect primaries has a direct connotation. I have to make this point, because when we make this argument against direct primaries, let us not forget that the Electoral Act section, I think section 81, either 81 or 82 of the 2022 Electoral Act stated that any political parties that chooses the indirect primaries mode must enshrine in its constitution and guidelines the democratic mode of electing the delegates. It's important. What does this mean? Now, it means that before the primaries itself, you're supposed to have a delegate congress. And in the delegate congress, all the members of the party are still to come and more or less transfer their voting rights to a group of persons.
But that would have also come in the process of the different layers of the groups in the party, from the ward to the LG, from the LG to the state and the national. You would have determined, just a moment, sir, you would have determined the ward delegates.
Yes.
You have determined the local government delegate. You would have determined the state delegate.
Now, can I tell you something? You see, in the if you recall, after the promulgation of the 2022 Electoral Act, you recall there was an amendment that was pushed in the National Assembly that the then President, late Muhammad Buhari, refused to sign, where it was discovered, because previously, you have two types of delegates. We have the statutory delegates, those who by virtue of their position are already determined by the constitution of the party. Either those delegates are either officers of the party or certain elected members, either members of the National Assembly or the governor of the state or members of the House of Assembly or elected local government chairmen.
Determined by
the constitution
of the party.
Now, in introducing the 2022 Electoral Act, that particular section, the National Assembly stated that they did not know, more or less, inadvertently, they expunged the provision that allowed political parties to determine statutory delegates. So to that extent, he says the only mode of delegate allowed under the 2022 Electoral Act were what we call ad hoc delegates, because the Electoral Act said that you must specify in your guideline the democratic manner of electing those delegates. The emphasis on the word democratic manner. Democratic manner means that the members of the party will say have to come and vote to determine who those ad hoc delegates would be. Exactly. And so, more or less, what you're now having in an indirect primary is that you already have a direct mode of electing delegates. Before those delegates will not go in turn and vote for the candidates of the political party.
The argument here is that there were, before the introduction in the 2022 Electoral Act of the consensus as a form of primary,
nomination of candidates,
there were only two forms of primary.
Absolutely.
The direct and
mode
indirect.
And indirect, yes.
And there are those who say, look, we didn't need to remove any. You should have allow a democracy in such a way that you give the people options, the political party, introduce one. That is
the option. That is the position of IPAC. IPAC is of the opinion that yes, as much as you agree, for example, like I said earlier on, for us in APGA, we have already mooted the idea of amending our constitution to incorporate only the direct mode of primaries. That doesn't mean that that mode of primary suits another political party. And so the position of IPAC is that the National Assembly ought to have allowed that measure of flexibility. What I don't know is what led to the decision by the National Assembly to expunge the indirect mode of primaries.
But you see, these are the issues.
Yes.
You remember during COVID, those election and primaries that took place, there were specific instructions, and those political parties that decided that they were going to use direct primaries, they were even cautioned that using direct primaries in COVID period is dangerous, having people to cluster around. That's one argument. Just a moment, sir.
I do not. Let me tell you why. Let me
just a moment.
Okay.
The other argument is logistics and the costs.
That is where the point is.
Of organizing a direct primary. That the bigger political parties have the muscle to be able to, and that's why an APC will be thinking of the possibility of it, an ADC will, because of the size now, will be thinking of it, a PDP will be thinking of it. There are other political parties that are not as big.
No, I think the 2 points you made, I only agree with the issue of logistics challenges for political parties. Why do I say that I do not really agree with the issue of saying the COVID whatever? Remember,
no, there was COVID. I'm saying that I'm just reminding everyone
even then,
about the COVID era and what happened.
That during the COVID era, there were protocols that guided human communication and interferences in issues, because during COVID period there were elections. It's not as if you're going to have an indirect mode of electing a candidate at an election. And so for the fact that INEC can actually conducted elections during COVID, political parties can equally conduct direct primaries during COVID. And so for me, that issue does not arise. But the issue that arises, like you rightly said, is, and that is the opinion of IPAC. The opinion of IPAC is that the position of the National Assembly on the mode of primaries more or less tries to stifle the growth of smaller political parties who may not have the logistics wherewithal to organize direct primaries at a large scale, especially when you take into consideration the nomination of something like the presidential candidate at an election, where you will be conducting primaries in about 8,800 and something watts in the entire country. So when you look at all these issues, like you rightly identified, the major challenge is, for me, with the logistics associated with the conduct of direct primaries. That's the major challenge, and that is the major reason why IPAC is calling on the National Assembly to reintroduce the indirect mode of primaries. And for me, I quite agree with that point. For us in APGA, like I said, we had already mooted the idea of having the direct primaries as the only mode of primaries in our constitution. But then political parties ought to be allowed the leverage to adopt the style that best suits them.
I mean, and you look at the irony. You know how many votes gave President Muhammadu Buhari the ticket of the APC before the 2019 election. What was the vote that he garnered at the general election? There are those who say some of these direct primary votes.
We've had this issue in my state, where, if you recall, in 2021, the primaries that brought the APC gubernatorial candidate, distinguished Senator Wandiuba, I think he scored about 500 and something thousand votes. And then even though at the end of the day, the Supreme Court later nullified the primaries based on the reports that the INEC submitted. But the point is that during the main election, I think he wasn't able to score up to 100,000 votes. Meanwhile, from the direct, so you still come to the challenges. Because you see, the most important thing in any issue is not about the provisions of the law. I'm one of those that believe that certain provisions of the law are adequate to take care of certain exigencies that may arise either in the conduct of elections or in the conduct of party primaries or in the nomination process. However, the major issue is how human beings, officials, and those who are directly involved in the carrying out or activation of those exercises, how they eventually carry out those exercises are what has been inimical in the will of progress or development or even democratic, building strong democratic institutions in this country. The 2022 Electoral Act for me was very okay. The 2026 Electoral Act as it is, still very okay. The most important thing, like I said, is that as a country, we must endeavor that institutions that are imbued with responsibilities to discharge certain duties imposed by the Constitution or by any relevant law for the time being enforced are actually made to do those diligent in line with the provisions of the law.
Yeah, that's not the only reason why IPAC threatened to boycott.
Of course. The second reason, like I said, is the provision of Section 77.
Yeah,
which for me is the one that I have issues with. In 2022, there was an innovative provision. That innovation was political parties were now mandated to submit their register to INEC before an election. However, during the election cases that arose from the conduct of the 2023 election, the Supreme Court took the position because for some political parties, they challenged the nomination of some persons who eventually won the election on the grounds that they registered either that their political party did not comply with that section that said that you must submit your register to INEC, or that even the register that they submitted, some of the persons who won elections on their platform, their names were not contained in those registers. And the Supreme Court stated that that particular section 77 of the 2022 Electoral Act did not contain any sanction whatsoever for failure to comply. And so what the National Assembly has now done, of course, is to introduce some sanction for me, which is a welcome development. But however, there are still some issues. And what are the issues? One, if you juxtapose the provision of Section 77 with the provision of the Constitution that allows for freedom of association, and even the provision of the Constitution that creates or enables the creation of political parties and determines and empowers political parties through their own constitution and guideline to determine the rights and privileges of their members. So what the National Assembly has now done is to now create different, what I may call different levels of membership, distinct from the provisions of the constitution of the political party. And for me, that has taken away the flexibility that political parties have in determining their right and privilege. Because, you see, if we belong to a political party, it is that political party that should define our rights and privileges, not for the commission. And what has the commission done? The commission has now created different levels of membership by saying that before a primaries, first, you must submit your register 21 days. First of all, it stipulates the digitization process, that every political party must maintain a digital register and specifies the information that must be contained. Of course, I'm going to still come to how it affects APGA and what we have done even before the present Electoral Act.
And that's why IPAC and members of IPAC, the position in that communique is to the fact that this looks like a booby trap for some political parties.
I agree.
Because according to them, the APC had known this ahead somewhat, and they've started the process. That is the thinking.
I do not
that
agree.
is the thinking of some members of IPAC who
I do not.
Look, it looked like a booby trap some political parties. Considering the fact that timeline of the election is now shrinking.
For me, there are allegations you bring in, especially allegations that you cannot substantiate. You begin to what I may call obfuscate the real issues. Talking about whether APC had have prior knowledge of the provisions of this law, for me, is immaterial at this point. Why do I say this? Anybody can equally make the allegation that APGA had prior knowledge of this Electoral Act, because we were the first political party under the current dispensation to digitize our membership. We introduced the electronic registration of members of APGA on the 1st of June 2024. So, are you going to make the argument that APGA had prior knowledge of? So, if a political party decides to be innovative, we must applaud that political party. Even for APC, as I meant to understand, their registration did not capture NIM, which is still the problem that we have now. Because when we flagged up our registration, we captured various fields, apart from the polling unit. Because in our constitution, the list or the smallest base of registration as a member of a political party is the ward. And so we didn't really, capture any information containing the polling unit of a member of APGA. So under the new Electoral Act, Section 77, subsection 2, has now introduced the polling unit and the NIN. And so what we have done now to start, of course, we'll now begin to revalidate. Exactly. Yeah. So that's
but
what...
in any case, I would like to ask, will an APGA said, National Assembly, should you refuse to fix some of these loopholes, we are likely to boycott this election. Do you agree with that position?
Well, I do not agree with the position as much as it is the position of IPAC. For me...
so you are one of the political parties that did not vote for boycott of the election at that meeting?
Well, when you talk about voting, well, yes, I think, let me tell you, first, we had a meeting, we convened the General Assembly, where the decision concerning any issue about IPAC by our constitution is determined by a voting process. And at the voting process, IPAC will, at the end of the voting, determine the majority, because like we say in democracy, the minority will have their say, but the majority will have their way. For us in APGA, we believe that the issue of boycott of election has not arisen. Because if you say you boycott an election, you create a constitutional crisis. Whether you like it or not, there are timelines recognized under the Constitution of the Federal Republic of Nigeria, as well as the Electoral Act, when the tenure of office of an incumbent must expire. And there are timelines within which you must conduct the election before that tenure of office. So what you are trying to do is to create what I may call a constitutional crisis. But then, for me, the most important thing is that the National Assembly ought to look at starting, because all of us are partners in democracy, whether you like it or not. We are all interested in having a strong democratic institution and political parties that will make. So the position of IPAC is, yes, as innovative as this provision is, looking at the timeline that INEC, because INEC has released timetable, and I'm even going to come to another point, which is, for me, what INEC did in their timetable that is very wrong. The INEC in their timetable seems to have created a different timeline distinct from what is contained in the Act. The Act mandated political parties to submit their register 21 days before their primaries. Now, INEC in their timetable has specified a specific timeline when political parties must submit register, for me, which is very wrong. What does it mean? In INEC timeline, political parties ought to submit their register between the 1st of April to the 23rd of April. Now, if you do a simple logical analysis or reasoning, if my primaries is on the 27th of May, what I should do is simply to count 21 days backward and submit my register. So it's not about compliance with the INEC timetable. It ought to be compliance with the provisions of the law. And so by creating a specific timeline, okay, what are political parties that are probably to conduct their convention or primaries maybe on the 23rd? Would they have complied with the timeline that you have provided?
Let me quickly, and I'll come back to a few of the issues. I know that APGA has really aligned forces with some parties at the center. In 2023, you did the same. In 2027, have you agreed that you are still working with the APC?
Well, of course, I've answered this question severally. Our position as a political party is known. And it's not a position that I took as the national chairman of APGA. It's more or less, it dates back to history. Maybe as far back as 2011, when President Goodluck Jonathan was the candidate of the People's Democratic Party. And then the leaders of the party at that time decided that more or less to craft a policy where the party more or less aligns with the party at the center. And till date, that policy has not been reversed. And so to that extent, APGA as a political party stands aligned with the government at the center, the government of President Bola Ahmed Tinubu. That is a fact.
So in Anambra State, where your party holds sway,
yes,
it's going to be APGA that Governor Soludo will be directed by the party to work for.
APGA or APC?
I mean, I'm saying that the APGA government of APC, of APGA of Anambra State,
of course,
will be working for the APC in the 2027 election.
When you talk about now, I was coming to that. You know, I just made reference or I made allusion to the policy that was crafted by the leaders of the party at that time. However,
and it still subsists.
It still subsists. But this is subject to a ratification of that policy by the National Convention. It's not a decision that I can take. It's not a decision that the national leader can take.
Well, as of today, APGA is
APGA
APC at the national level.
With APGA stands
and it is Bola Tinubu and the APC.
Absolutely.
That is APGA for.
Absolutely.
Give me a moment. We need to go on a break. But when we return, there is so much more for us to touch on the elections of 2027 and some of the issues that have been raised. We'll be right back after this break, everyone. Join us again. So much everyone for staying with us on the program. We've been speaking with the national chairman of the All Progressive Grand Alliance, APGA, this barrister Sylvester Eze-Okenwa. But before we get back to our conversation about the 2027 elections and the implication of the amendment to the Electoral Act, I told you earlier about the meetings of the People's Democratic Party in the different parts of the city. On one hand, the caretaker committee of the Samuel Anyanwu group, and on the other hand is the Tinubu Turaki led group of the party. Fundamentally, both groups are planning for the future. But let me allow you to listen to some of the commentaries, some of the views of some of the leaders in the Tinubu Turaki group when they held a meeting earlier today.
I can only say, on behalf of, we're only two remaining, but we're not bothered. I can say personally, and on behalf of my chairman, that when the story of this period is told, and when the story of democracy in Nigeria is told, they will find us on the side of the people.
Correct side today. Correct side today.
So please, I can only say that this period will also go away. It will pass away. So whatever role we want to play as individuals and collectively as a party, we must be conscious of what history is going to record against or for us.
The board considers the judgment an order for the party to begin again. An order for the party to begin again. We are law, we respect the law, rule of law. So this is an opportunity for us to begin again. And that's why we're all here. When Iyom Josephine Aneni prayed for us, he said we should just forget about our personal interests and think about the party. It's not a day of speech making. is a day that we would have to be very serious with whatever decisions we are going to arrive at. And mainly, as we've always done in the board, we obey the Constitution. We must work in accordance with the Constitution. And you can never go wrong if you abide by the Constitution and the rule of law.
Since our convention in November last year in Ibadan, we strive to make sure that we do not only keep the hope of millions of Nigerians alive in democracy, in party politics, through the instrumentality of our party, but indeed we've worked hard to make sure that the fortunes of our party are increased. I leave you, indeed, and Nigerians to be the judge of whether the little we have done was positive and what impact it had made. I want to thank our chairman of BOT for convening this emergency expanded BOT meeting, because in the judgment of the Court of Appeal, Abuja Division yesterday, it becomes imperative that our leaders must sit and then consider the situation on the ground and then come up with workable and implementable options that will save this party and indeed save Nigeria's democracy. So there can never be a better time than now, especially when you look at the compacted nature of the 2026 Electoral Act that has been passed into law by the National Assembly. I pray and hope that at the end of the day, after probably this meeting, are taking briefing from our team of lawyers who are highly respected senior advocates of Nigeria, that we will have been given sufficient information to enable us to take decisions that will be in the overall interest of our party.
Those are the views and the thoughts of the leaders in the Tinubu Turuki group of the PDP, where we saw the two governors left in the PDP, Governor Sheyi Makinde of your state and Governor Bala Muhammad of Bauchi State, as well as Senator Adolphus Wabara, who is the BOT chair there. Let's get back to the conversation with Mr. Sylvester Eze Okenwa, who is the APGA national chairman. We're still waiting to hear back from IPAC on his stance on the Electoral Act amendment. Yeah. But I guess, and I know it's going to be difficult for the National Assembly to revisit. It's not impossible. Yeah. It's not impossible. It's not impossible. But I know that it might be a difficult, because they have the budget of 2026 on their hands. Absolutely. Now. The FCT budget is now being sent to them by the president. Revisiting that Electoral Act for the purpose of amending those gray areas might not be possible before the next election, which leaves us with wanting the threat of IPAC of a boycott.
Yeah. For me, as a leader of a political party, like I said earlier on, the issue of boycott of election, generates more or less certain critical constitutional issues that I will urge IPAC to revisit. I think it's important that we engage. In fact, I've spoken with the national chairman of IPAC on the possibility of convening a meeting or requesting for a meeting with the leadership of the National Assembly. It's not impossible that those certain gray areas have been highlighted by IPAC. The National Assembly, I believe that they can have the time to address it, in the interest of democracy, especially given the fact that you must allow political parties to thrive. It is important. And it's important, of course, the motto of IPAC is deepening democracy. And IPAC has shown to be one of the bodies, that has been imbued with the responsibility of safeguarding, if you may choose to call it our nascent democracy. And so it's important that the parties, all the parties, the political parties on one side and the leadership of the National Assembly come together and engage and look at the concerns that have been raised by IPAC, particularly the timeline for compliance with Section 77 of the Electoral Act and other issues or gray areas that have been highlighted by IPAC. I don't think that it's impossible. I really want to believe that there can be an amicable resolution to this issue.
The electronic transmission of results, which was an infusion, and there are debates on the modalities and how far you can go, either in real time or not real time, either simultaneously or not simultaneously. But the present way with the provisor, and has been defended by the leader of the Senate, Senator Poyami Bamidele, do you think that will effectively guarantee the kind of transparency, the trust, which has been a deficit in our electoral process that a lot of Nigerians are waiting for? Can it guarantee such a trust and accountability and transparency?
You see, I'm one of those that believe that Section 60, as it is particularly the provision of subsection 3, for me, really adds little or nothing to the ambit of our law. And I remember at a recent interview, I likened the whole controversy and impasse surrounding Section 60, particularly Section 60, subsection 3, the proviso to the issue of electronic transmission. I likened it to that particular popular book by William Shakespeare, Much Ado About Nothing, or what I may call is just a storm in a teacup. Why do I say this? First, it appears there has been so much misinformation and more or less ignorance on the part of the populace with regards to what electronic transmission of results practically connotes. Again, this has further been compounded by the confusion of even the term by the National Assembly in the Electoral Act. Why do I say this? That's what we call inelegant drafting, where you're using one word to mean two different things. First, if you look at Section 60, subsection 3, it talks about transmission of result to the IREV. So the first point is you have to understand what the IREV platform is. That's number one. The IREV platform, as the name connotes, is INEC Result Viewing Portal. It's merely a platform for viewing results as they come real time from polling unit. What it means is that you, my brother Shehu, you can sit in the comfort of your house, even if you're in Belgium. You can simply log on to INEC, the dedicated site, and view those results as they come. The second issue, is it that particular result in the IREV that INEC collates? The answer is no. That's the confusion.
It is not?
It is not the result that INEC collates. The polling unit's
result?
Yes.
It is supposed to be, actually.
No. The point is, INEC does not collate results from the IREV. That's the point.
No. It dumps it there.
It's there.
It puts a record of
exactly,
it there.
It's just record. Now, the result that INEC collates, and that's why I talked about inelegant drafting in using transmission to mean two different things. One is transmission to the electorate, to the IREV viewing portal. The second one is transmission in terms of the definition given to it under Section 62, subsection 1, which states that at the end of an election, that a presiding officer shall deliver the result of the polling unit to an officer as may be designated by the commission. And so, in another way, transmission now means taking that result to that officer.
All right, so
for collation.
Yeah, so let's break it down.
Now,
the essence, and for a lot of Nigerians, why this is important is double pronged.
Yes.
On one hand, is whether it can serve as an evidential document.
It is.
For adjudication.
It is.
Or for litigation purposes. On the other hand, there are those who will argue to say, if the duplicate and triplicate of results has been shared to police as a witness in an election at the polling unit and the party agents, why shouldn't the IREV portal result also be a copy Albeit a digital copy this time around.
Yes.
You have all of this copy given to agents.
Yes.
Which you can take to court.
Yes.
And you don't, I mean, INEC might be needing a certified copy.
Yes.
And there are those who will say, why do you need a certified copy, which is a copy that is produced original anyways? Why do you need to certify it to present as an evidence? The other part is that Nigerians, because of the trust deficit, want a situation where they can monitor and be able to see.
Of course.
And the fact that they want to be able to see it exactly at the time when this is happening. The question is technology.
Of course, this is where the issue now arises. Remember, this was the issue, the major or the most critical issue surrounding the 2023 election. The allegation that simply because results were not transmitted, that election lacked the needed integrity that it ought to have. And that's where I disagreed with certain persons in the 2023 elections. Why do I say this? You see, primarily, a political party has the duty to protect its result at every polling unit. That's the primary role of polling agent at an election. And so every political party, and I make an allusion in Anambra State, if not for the diligence of the polling agents that we had in 2003 election that Mr. Peter Obi contested and was rigged out, probably APGA wouldn't have been in place today. So it took the diligence. Of course, there was no IREF then. It took the diligence of the polling unit agents who were present at the polling unit, monitored the elections, signed the result, and obtained the duplicate copies of the result. And it was the result with which the party reclaimed its mandate at the tribunal. The same thing happened with most states in the Southwest. And so nothing can substitute or serve as substitute for the role of polling agents that has been guaranteed a primary role in the Electoral Act. Now, for the purposes of IREF, remember, the question becomes, if, for example, the result could not be transmitted, because that issue has been raised. You see, glitch is a word in the dictionary. I didn't put it there. And it is wrong or erroneous for anybody to assume that if there is an issue on election day that has to do with technology, that it probably has been premeditated. But the point I'm making is that in an election, as much as INEC has guaranteed the IREF as one of the transparent mechanisms, it wants to imbue or build up confidence in the electorate in the election process, we must be very careful in how these issues, especially issues bordering on electronic transmission, are managed. And
we're totally out of time. Mr. Sylvester Ezeokenwa, the APGA National Chairman, thanks so much indeed for your time.
Thank you so much. And I actually forgot before we started to say a very happy birthday to you.
Oh, thank you.
At least I was able to tell Nigerians that.
Thank you so much, everyone. Thanks so much for watching tonight. I'm sure Akimale. God bless Nigeria.